Hello there and welcome to the program where we talk on matters to do with law, justice and legal affairs to educate you, help you and learn new laws that govern you. And our topic of discussion today, we're going to base it on the law on divorce. Probably when people get married, they believe and the hope is that they stay forever. But again, there comes a time where there is compelling reasons for them to part ways. And today, that is what we're going to talk about, the law on divorce. What guides the divorce process here in Kenya, and what are the grounds that can lead to divorce? And with me to have that discussion is my guest, who is an advocate of the High Court of Kenya, Kevin Doho. Welcome to the program.
Asante sana.
As we begin this particular discussion, of course, it's a discussion that entails a lot of emotions and a lot of drainage of people who are involved in this particular matter of divorce. We begin at this point. How can we say that the divorce process is stipulated in the Kenyan law?
The Kenyan law has provided for divorce proceedings under the Marriage Act number 4 of 2014. It has a section on matrimonial causes such as divorce, annulment and separation, mostly to resolve those types of disputes which arise during the relationship of marriage. When you seek for divorce, usually at least 3 years after marriage, if you have celebrated it under the Part 4 of the Marriage Act, which is civil marriages. But for the other types of marriages, you have to go through a certain process. For example, for customary marriage, the Marriage Act provides that first you have to go through traditional dispute resolution mechanisms in your community before a court can be seized of jurisdiction to determine the dispute or the divorce petition. For Christian marriages, most of the time you find you go to the church, and the church has its own dispute resolution mechanism on mediation or taking care of the relationship so it doesn't break down. For Muslims, the Marriage Act provides that it's only Sharia law which applies. Obviously, Sharia law is the law of talaq, which is repeating the three words, I divorce you, I divorce you, I divorce you. Then you get the divorce. So it's governed under the Islamic rules, under Sharia law. For Hindu marriages, you have first to establish the grounds on which you want to rely on divorce. For example, you'll find either you were not aware that you are within the prohibited levels of relationships. For example, a cousin or nephew or something like that. Also, the Marriage Act provides for Hindu marriages various other grounds, such as when one of the parties has been convicted for rape, sodomy, bestiality, then we can be able now to be in a position as under Hindu law to file for divorce. The special thing about Hindu law is that part of the Marriage Act governing Hindu law is when one of the parties converts out of that religion, then you can petition for divorce. The other grounds are common between Christian, civil, and Hindu, are where a party deserts the other for at least 3 years, where there is what we call idolatry, where we have things to do with the relationship as irretrievably broken down, and convictions. For example, if you are convicted for more than 7 years, one party is convicted for more than 7 years or life, the other party can apply to have can petition for divorce.
And on that note, of course, it's a process that has to be followed in filing a divorce. Now, assuming that a person wants to file a divorce, where do they begin from, and where does that divorce end, and the entire process? Can we just define the entire process on where it begins and where it ends?
Under the Marriage Act, the court that is seized with divorce proceedings is a resident marriage magistrate's court, unless the dispute involves property which is worth much more, or the complexity of the issues are very complex. For example, where you have high net worth individuals, but you start at the magistrate's court. You file for, if you go to your lawyer who prepares a petition of divorce, then it is filed in court. Once it's filed in court, the court may set aside the hearing of that petition for maximum of 6 months as it investigates the issues being raised and also tries to get the parties to reconcile. Then from there you go to the hearing where one of the parties is alleging the petition for divorce and the other can either choose to not file a response or just file a response. Either maybe it's a wife who has filed for divorce and the husband is challenging that there are no grounds for divorce. Once the judge hears both sides, the magistrate hears both sides, he will make a decision. That decision will, if he is satisfied, he will grant not divorce but a decree nisi. So a decree nisi is a grant saying, yes, the court agrees with you that there should be divorce, but you have to, before you get the final divorce, you have to go maybe 3-4 months, then you come back for a final decree that now declares you divorced. So between the decree nisi and the final decree, you have separation. So you stay apart, and then after that, when the court is satisfied that you people are not coming back together, it will now give you a final decree declaring you divorced. That means that the marriage has come to an end. Yes.
And in determining the divorce case, or rather coming to a conclusion that this is supposed to be a divorce, are there some of the submissions by the petitioner, maybe the wife who filed the divorce, are there grounds that the court can reject and say that the particular grounds filed for divorce are not valid?
For example, you might find for civil marriages, you cannot file a petition for divorce within 3 years. You have to wait for 3 years to elapse, then you file for divorce. So you might have all the other grounds, correct? Maybe there was adultery, there is irreconcilable differences, or one of the parties has gone insane, or there was some material fact that was not disclosed, that was there was a mistake during the entry into marriage. So the court will set aside that petition for divorce or dismiss it until you have 3 years elapsing. That is now one of the ways where the court will refuse to grant it. But ordinarily, from our time, or from this time in the world, divorce has become easier to attain. You find there is a judgment from, I think, Justice Nyakundi, where he says that basically you can presume divorce. You don't need to file for divorce. That's a judgment that has been issued. Because obviously if parties have separated over a long period of time, maybe 20-30 years, there is no need for them to come in and to court and say, we need a divorce. So sometimes the courts at this time presume there is divorce. So those grounds, you have to plead them, show them in court, and provide evidence of what you are talking about.
Here is a wife who has filed a divorce on certain grounds, and here is the husband who is now declining the divorce, claiming that these grounds are not sufficient and nothing like this happened. What does the court now do to determine the truth of these grounds so that it can be able to make a ruling on the divorce case?
Family law, especially divorce cases, are very sensitive. They are very emotive. You might find a party coming to court alleging adultery. So you might find maybe the man is maybe a politician or a judge or a bishop somewhere, and there's a petition that has been filed by a spouse saying that my husband does this and this with this person and this person. So the husband may come to court and say, I never committed adultery, there's nothing like that. These are just allegations which have no evidence of what happened. So you might find the court now, instead of giving a decree of divorce based on adultery, it will now look at the parties and say, can't you people agree and reconcile? If you don't, then you can come back and file file fresh grounds for divorce, maybe on irreconcilable differences. So not every ground is allowed. So if, for example, you are alleging adultery, either or you're alleging insanity, or you're alleging depraved, because one of the grounds of divorce is depraved acts on the other spouse. So you might you might have to prove those depraved acts in court. So the other spouse may totally deny he did any depraved act to the other spouse. So these are usually facts that have everybody has his own side of the story.
One of the partners, per se the man, claims that our marriage still exists, and then there goes the wife was going to court and said, we've been separate for a very long period of time, and I want the court now to consider this as a divorce. At that point, will the court presume divorce, or will it to go again on the procedure of finding out if indeed this is a marriage that's supposed to undergo a divorce?
Most of the time when there is desertion, that's what you're speaking of, a desertion for a period of 3 or more years, and you have to have proved it by the time you're filing the petition. At least 2 years before you file the petition, there was no support, there was no community, there was no society between the spouses. Then the court will now look at that evidence and then make a determination that indeed this is a good ground for divorce, and I declare the divorce in the decree. That is now how the court will approach it. For these other parts where we have desertion and the person has disappeared for more than 7 years, you may have that person declared dead. Once they is declared dead, obviously determines it ends marriage. So you might have to think between those 2-3 angles about the period, a long period of time spent apart. Yes.
Are there automatic grounds that can declare a marriage divorced?
Well, they are not. Divorce is not really automatic. What is automatic or is presumed automatic is annulment, which is a different area of law. So divorce presumes there was marriage, and because of the way society has protected marriage, it has not ever been available for instant divorce, or what you call no-fault divorce, as maybe in California or other jurisdictions in the world, where you just file and basically just get the divorce papers in your mail, you sign, and that's it. Here in Kenya, we still have not gotten to that point of no-fault divorce. There is no automatic divorce in Kenya. All we can do is presume there was no marriage. That is annulment. Yes.
You mentioned about fault-based divorce system and the non-fault. Yes. So what is the difference between the two? Because I understand people might be thinking, yes, what is fault divorce system and non-fault divorce system?
What happens is, fault divorce is where one party does something that the other party finds offensive or finds impossible to continue the marriage, or one party suffers from a condition, maybe insanity, that the other party cannot abide in the marriage. That is a fault. That is now the cause. Now, no fault is you just come to court and you say, I want to get divorced. You don't give any grounds, you don't give any reasons, you just want to get divorced. You just write a letter to court, I'm getting divorced, we are getting divorced. What the court will look at is your signature legitimate? Then grant you your divorce. No fault. You don't have to prove adultery, depravity, insanity, or anything. You just automatic. And with the more liberal societies going, we might have that type of divorce spreading throughout the world. Yes.
No fault divorce system, does it have consequences from where you sit?
It has huge consequences. For example, you might sleep one day married, and then you wake up the other day you're not married. So you might have those types of scary situations. However, these are divorce laws. When you really look at them, they speak to the value system of the society. As lawyers, we do not have the authority to tell you your values. Those values are either set by the church, the mosque, the Hindu temple, or by the way people live their lives, according to faith or according to their own beliefs. So as a majority in society move away from religious worldviews, you might find yourself having changing laws. So you might move from very strict marriage laws to very loose marriage laws. The breakdown of society obviously will increase, but we hope that marriage will not be a thing of the past. Divorce will not be as easy to get as maybe some other places in the world. We usually look at marriage as something that should last. It's something that should be durable. It's one of the founding stones of society. Yes.
With the current world and the current change of things as the world continues to evolve, and a world that is characterized by greed, of course, there are those grounds of divorce that will be submitted out of self-interest, and somebody wants to gain one thing or the other from maybe a divorce, per se, like something like shared of properties. How does the court deal now with the self-centered and self-interest grounds that one is pushing for divorce?
You might find that when you are dealing with property and things to do with greed, you must first finalize with the dissolution of that marriage through divorce. So first you start with divorce, then you go to the matrimonial property, which is not under the matrimonial causes part of the Marriage Act. Now the law provides that a spouse is entitled to maintenance until he is able to support himself or herself, or until she marries or he remarries. So that is the law as it is. Now, how to divide that property has been a controversy for many years. There was a time in this country where when you divorce, the wife would take half and the husband could also take half. Now, the way the law is written, it is that you have to prove contribution. So contribution has been an amorphous thing. Did you contribute to the purchase of the property? Did you contribute to the maintenance of the property? Things like that. But it has come out in recent times, or just about last month, where a judge pronounced and said even giving birth is a full-time job, being a housewife is a full-time job, and that type of job has to be a contribution into that marriage. So to deal with these things to do with divorce, the courts have now rewritten the law and pronounced that you have to prove contribution. And then the law was amended in 2014 to provide a way to prove that contribution, so that whatever intentions somebody had in getting married, you can't get married maybe for 1 year, then take half the property of one man, then marry another one, do the same thing until you have accumulated a lot of property. So you must have sanity in the law. So you might find what you contribute to that marriage in 1 year is not like something when somebody has lived with a man for over 40 years or 30 or 20 years. That is a huge contribution to that man's world. So you'll be able now to get what you put in is what you get out. So that is now the recalibration that has happened in the law to make marriage, the man and the woman in marriage, to be equals. Yes.
Is there a stipulated time that once you're freshly married, you should stay for this particular time before filing for a divorce?
Yes. If you married under the civil marriages, the one from the AGs, you have to at least stay married for 3 years. For the others, there's no stipulation in law on the period of time. But for Muslim marriages, they are covered under the Sharia law. For Hindu marriages, they are covered under the Hindu law and those grounds of divorce. For Christian marriages, there is no limitation of 3 years. No. You can file for divorce even after 2 days. But you have to go under your own religion. So, for example, if you're Catholic, you might find yourself having various challenges filing for divorce, because obviously your own belief system will be in conflict. So most of the time, the one which is limited is the civil marriages. Yes.
And on that note, do we A conflict between the customs, or rather the cultural customs, and the law in terms of determining whether a marriage should be divorced?
For cultural marriages, there are grounds of divorce which have been codified in the Marriage Act. They just look like the ones for the Christian marriage. But they have the added obligation, before you seek divorce, you have to go for conciliation under the tribal system. The wazes, the barazas, the parents, things like that. But I don't believe there is any conflict between those two value systems. What is happening is where a man contracts a marriage, a monogamous marriage in church, the Christian marriage, then later on conducts another marriage and a custom. So the law has provided that you can convert a monogamous marriage to a polygamous marriage, but with the consent of the spouse, the first spouse. The law has also provided that you can convert a polygamous marriage to a monogamous marriage, but you cannot be married to other women. So, and you have to get the consent of all the others. So you have that type of balance. Now, when there is a divorce and a custom, the law has provided. When there is a divorce under the civil or Christian marriage, there is a process. So those processes just have a way of merging, and the way the grounds are written, they are nearly similar. So a judge will have an easier time now, because everything has been codified on how to proceed when faced with various parties from various cultures, from various socioeconomic classes, and they have come to her or him for a divorce. So they've tried to clarify that, and it's a beautiful thing, because previously we had so many marriage acts, about 6, 7. Subordinate Courts Maintenance Act. We had various Mohammedan Marriages Act, the African Christian Marriages Act, we had the Marriage Act. So the judge would have been a little bit would have found it a little bit difficult on how to proceed when faced with a petition for divorce, when there's interrelations between African Christian and cultural marriage. But now that there is a clear, it's one act and it has one process and nearly similar grounds, it's easier now to proceed.
So we don't see a scenario where a marriage has been terminated, or rather divorced under the custom or cultural laws. Don't we see a scenario where one of the parties gets dissatisfied with the way the marriage was terminated and the customary laws, or rather the cultural laws, and then now wants to run to the court to seek a nullification of such a determination?
You see, all that the cultural council or the tribal system is doing is conciliation. It is not determining or ending the marriage. Customary marriage can only be effected by court. So you go, you sit down with the wazir. If you can't agree, you come to court. You come to court, but you can't come to court directly. You first have to go through that process. So the court will determine the whole issues that have arisen and either grant divorce or refuse to grant it based on what the parties have brought before the court.
And now, as we come to the conclusion of the entire discussion, of course, you mentioned about annulment of marriage and divorce. What is the difference between annulment of marriage and divorce?
The difference is that divorce presumes there was a marriage that has now come to an end. Annulment presumes there was no marriage to begin with, so right now there is no marriage. So for example, one of the grounds of annulment is at the time of celebrating the marriage, only one party was present. So there was no marriage to start with. For example, you might find yourself, you're getting married and the bride is taken too long, so the guy just decides to just sign. Then the bride comes and signs later, maybe the next day. Now that is one ground of annulment. Another ground of annulment is during that celebration, one of the parties did not understand what he was doing. Either he was insane, or he was intoxicated to the point where he doesn't know what he's doing, or his consent was procured by fraud or misrepresentation, or at the time of marriage, the woman was pregnant by another man's, the pregnancy did not belong to the man she's marrying. There are various grounds to annul, or the couple comes to realize, by the way, we are related, we are cousins, we are brother and sister. So now they come to court and they say to the court, please annul this marriage because of these grounds. Then the court will annul the marriage, saying there was no marriage because of these various reasons. So that is the difference between annulment and divorce. Yes.
And that is where we wind it up on the annulment and the difference between annulment and divorce. And thank you so much for making time to have this particular discussion. And again, that is where we end up our discussion on the law on divorce. Hopefully you have been educated, you have learned on how the law on divorce works in this particular state, especially in Kenya, where the law on divorce has to have grounds on which you're filing a petition to claim a divorce. And that is where we end it up. Thank you for always making time to watch this particular program, and make sure you catch our previous episode where we talked on the matters to do with law on marriages, so that you can get to understand how you can get married under the Kenyan law, and again how you can divorce under the Kenyan law. And that is what we have for you tonight. My name is Chris Sambo. Goodbye and see you in the next episode.
Kwenye makala ya jukwaa la moderator.
Tunapojiweka mbele katika mambo yote tunayofanya, huwa tumeenda kinyume na matakwa ya Mwenyezi Mungu. Hasira moja iliyokuwa na Mungu ni kuhusu watu wanaojipenda. Kazi ya Mungu inapaswa kupewa kipaumbele. Hivyo kuna uwezekano ya kwamba tukisikiza ushauri wa Mungu kwa njia inayofaa, tutakuwa sawa kwake, sababu Mungu ana rehema na anatupenda.
Jiunge na moderator wa kanisa la PCA Mchungaji Thegu Mutahi kwa mahubiri, mafunzo na ufafanuzi wa masuala ibuka nchini, kila Jumapili ya kwanza ya kila mwezi saa 1:30 jioni. Hapa KAK TV.
Tafakari njia zako.
Karibuni. Welcome to PCMF Week 2021. This will commence from 1st to 7th of November. We are thankful to God that another opportune time has come as we share on the theme